Justice Gorsuch? Justice Kavanaugh?
Your statutory interpretation has force, but I had some concern at the stay stage, and I have some concern now about mens rea. And this is an agency regulation that broadens a criminal statute beyond what it had been before. So what about the seller, for example, who is truly not aware that they are violating the law and gets criminally charged? What assurances can you give about mens rea, about instructions to the jury that the government would seek and the like?
So let me begin with the statutory mens rea standard that I think fully addresses this concern. This is in 18 U.S.C. 924A1D, and it requires willfulness. So that means that if a manufacturer isn't putting a serial number on it because the manufacturer believes in good faith that this isn't a regulated product and the manufacturer doesn't know that it's violating the law, it will not be criminally chargeable because the government won't be able to prove that mens rea of willfulness. So I think that's an important check against criminal prosecutions that might be unwarranted. The second thing I would point to is—
Does this willfully apply to all potential prosecutions that we're talking about in this case?
It applies if there's no serial number on the weapon, and it applies if the weapon is being sold without a license. I believe that with respect to not conducting a background check, that's under a different provision that requires knowledge. But of course, the kind of entry point for the weapon is whether or not it has a serial number, and that happens at the point of manufacture. I also want to emphasize that to the extent that there is really—
So how would that work on the background check? I just want to make sure I'm not missing something there.
Yeah, so I think on the background check, if you have a seller out there who wants guidance about whether with respect to particular type of products it's necessary to do that background check, the person can seek a classification from ATF. The manufacturers would be the ones to do this, and this is a way to get a pre-enforcement dispositive ruling from ATF as to whether that's deemed a regulated firearm. And in that circumstance, if you don't like the answer that ATF gives, you have a right to judicial review that will be conducted under a de novo standard about whether this is a covered product.
But if you haven't done that, so you haven't done that, and you truly, take the hypothetical, you truly believe you're not violating the law, could you be charged under that provision?
As a theoretical possibility, I think only with respect to background checks, it's possible you could. I'm not aware of any prosecutions that look like this, and the whole point—
Is that something the government would do?
I don't think that the government would be likely to charge someone in that kind of situation. And it doesn't look anything like what was happening, where the manufacturers were themselves the sellers, putting these products on the market with explicit knowledge that it was being put into the hands of teenagers, felons, and so forth.
That's helpful. Anything else you wanted to finish up with on that?
So I guess the only other thing I would say is that we think that there is a lot of protection for manufacturers who are seeking to comply with the law in good faith. ATF is not trying to hide the ball here. The point of the agency is not a game of gotcha to try to criminally prosecute people. There was a very serious public safety threat posed by the explosion and the use of these ghost guns in crimes. And so the whole point of this regulation is simply to put the regulated industry on notice of how the statute applies in that discrete context and how it's always applied since the statute was enacted.
And on that point, because you had a lot of classification letters that were out there, this was to collect everything and put everyone, as you say, on notice, adding a couple things, as you pointed out earlier, correct?
Right. And so I don't think that this is any vast expansion of the statute. We just think this is ATF's longstanding interpretation with the addition, with the addition of looking at jigs. But to be clear, that doesn't change the meaning of the statute. It just changes the factors that are relevant under the statute when you're conducting a readily analysis.
Okay, that's helpful. Thank you.